Mhm. Testing, testing the sound on the inquiry live stream.
Okay. Yeah.
When I've had mine, I'll live off the wine.
Okay.
Right, good morning. It's just approaching 10:45. Just checking if everyone is here who should be here, because I'm not as familiar with Zoom as maybe other forms of online meeting, and I'm just going to have a quick scroll across to just check the participants. It might be worth everyone introducing themselves one by one first. So I'll do me first, just for the record, for those who may not have been involved in the inquiry to date and are just observing today. My name is Gareth Wildgoose. I'm an inspector appointed by the Secretary of State to undertake this inquiry to the proposed funeral ceremony building at Hale Road in Farnham. Next participant, please.
I go next, sir. That's the appellant, Charlie
Yeah.
Banner, KC, barrister for the appellant. Good morning to you.
Thank you, Mr. Banner. We'll go through the appellants first, and then we'll move on to the council, then any interested parties. Thank you, Mr. Banner. Any other representatives from for the appellant?
Thank you, sir. It's Robert Still here, planning consultant on behalf of the appellant.
Thank you. And are you the only representative today, Mr. Steele?
There are others on the call.
Yeah, others
Hello.
on the call that you'll call upon, and if they can just introduce themselves if they do participate.
Sure. Thank you.
Okay, for the council.
Good morning, sir. I'm Robin Green. I'm the barrister instructed by Waverley Borough Council.
Good morning, sir.
Thank you, Mr. Green.
Robert Collett, planning consultant instructed on behalf of the council.
Thank you.
And we have got Sir Russell Brown, Principal Planning Officer from Waverley Borough Council on the call, and we'll call Mr. Brown as necessary.
Thank you, Mr. Collett. It's likely that I will add Mr. Brown to the attendees, but it'll be marked as conditions only, because obviously understand that it's without prejudice to the council's position, the involvement today. Thank you.
Good morning, sir. My name is Steve Tilbury. I'm a planning consultant advising Farnham Town Council as an interested party.
Thank you, Mr. Tilbury.
Good morning, sir. My name is Councillor Catherine Powell. I'm representing the residents today.
Thank you, Councillor Powell.
Morning, sir. I'm Councillor Carol Coburn. I'm on the Waverley Planning Committee, and I also was the chair of the Neighbourhood Plan Group and of the review plan. Thank you, sir.
Thank you, Councillor Coburn. Anyone else wishing to participate today, or is everyone else just sat in the background for now? If there's no one who thinks they're going to participate now, or they do feel the need to discuss any matter at any point and come in, then if they can just introduce themselves so I can make a note, so we've got an accurate record of them.
Madeline Gibb, local resident and interested party.
Thank you, Ms. Gibb. Sorry, I didn't notice you on the list there.
Thank you.
Good morning, sir. James Calloway. I may chip in on the conditions. I work alongside Robert Still at Savills. Thank you, Mr. Calloway. Similar to Mr. Brown. If you do chip in, I'll just put conditions only on the attendance list on the back of the decision letter, if that's okay with you. Thank you. Thank you. Anyone further before we proceed? Okay. People are at their own discretion. You can turn off your camera should you wish to do so. And please keep your microphone muted until I invite anyone in for comment. Typically, I'll invite comments. My expectation is that the council, Mr. Banner.
Sorry, sir. No, I was just going to say something when you finish. So do finish. Sorry.
Okay, no problem. Yeah. So I'll typically invite the council to respond first, then any interested parties if there's any particular comments, and then the appellant have the final word on each of the conditions. Because of the work that we've undertaken to date, with my feedback on the potential conditions that were provided helpfully in the statements of common ground, that there aren't a great amount of questions that I have. There's just a few points of clarification, but there will be an opportunity for others to comment on the changes that have been made to date in IQ11. And I know there is an updated version that has been provided, and we'll talk about that in the housekeeping in a moment. I am going to refer to the condition numbers as they are in the statement of common ground to avoid confusion. But obviously with reference to changes in IQ11, because others may not have the further updates to the document, but the council and the appellant may want to update in terms of any revisions that have taken place since the discussions on Tuesday accordingly. I haven't got anything further, Mr. Banner. So did you have something to add?
Yes, just to say from our perspective, given that Mr. Steele and Mr. Callaway will lead on conditions, if you're content, I will, unless I'm needed at any point, go off screen or certainly on mute, because as we've agreed, Mr. Green's very kindly sent me his draft, well, his actual closing, not just draft, his actual closing a few minutes ago. And so that you have mine in advance, I'm just going to incorporate my responses now. So unless you need me or my team needs me, I'll just go off camera if I may. And
if you can just stay for the housekeeping and
yes,
we'll do the procedural stuff, and then yes, entirely at your discretion to then mute yourself and turn your camera off. That's fine. We'll just anything further, Mr. Green, before we get into housekeeping?
No, sir. You may have gathered from my voice that I'm struggling a little bit, so it may be that Mr. Collett will certainly bear most of the burden when it comes to conditions. If during the course of my closing submissions I falter, again, it may be that Mr. Collett will take over, but I hope it won't come to that.
Thank you, Mr. Green. Noted, and I hope that you can manage through it. But note that if it's needed, that's absolutely fine, because I'll have the written version before me when we move on to closings later in the day. And similar to Mr. Banner, happy for you to sit in the background on the condition session and just chip in as necessary if there's a legal matter that were to arise.
Thank you very much.
Thank you. Just in terms of the housekeeping matters generally, just to update everyone, the document that I did briefly refer to is the further revised conditions document. Can either of the parties just advise me on the updates to that to IQ11 that were in that particular document? I have reviewed it, but I didn't have the opportunity to do a very detailed compare and contrast between the documents to kind of ascertain what the differences were in there.
I might suggest Mr. Steele from our part, as he was the holder of the pen, so to speak, clarifies the position.
Yes, sir. So in terms of the latest document with your comments, you now also have a document with the appellant's comments within, and also the council's comments within. With the latest position, which includes a comment I made on condition 3 in regards to a question at the inquiry on day 4.
Yes, I thought
that should be your latest one.
Yes, thank you, Mr. Steele. I noted that change at condition 3. I was just making sure that there weren't any other detailed changes other than those additions to comments, because of obviously if something had arisen and I hadn't picked it up, but that's helpful to me. My suggestion, Mr. Callaway.
Yes, just on that, I wanted to check that there are some track changes that appear to be accepted. I wanted to ask the council whether we should read that as the council agree to that.
That's fine for response. I was taking it as agreement. My suggestion was, once we do get into the discussion today, that I run through each condition very quickly in terms of where things are, what I perceive as having been done, and then if I've no further questions, give the opportunity for parties and/or interested parties to actually comment at that stage before moving on to the next one. Obviously, the work today has streamlined a lot of the issues because it's addressed some of the wording changes and refinements that maybe were needed that I'd kind of flagged up But obviously there are some outstanding points of dispute between the parties that maybe need a little bit further discussion. But the council might want to clarify their position. It was my understanding. My understanding was the same as yours, Mr. Callaway, but the council obviously can't speak for the council, so I'll let them provide any clarification at this point.
Yeah, thank you, sir. And yeah, that is exactly right. The track changes I think have been accepted. There are some outstanding comments that have been made, and they're the points which we'd anticipated our discussion would focus on today. I'm clearly happy to go through them, sir. One by one, just to make sure everyone is agreed. But yeah, I think the general text changes were generally accepted.
Yes, obviously in terms of the changes to IQ11 on condition 3, we may need a bit more. We may need to clarify for parties who don't have a copy of that document the changes. So I will run through them and so on. But otherwise, typically I'll rely on IQ11. My suggestion is that we accept the revised document with the revised condition 3 for certainty as IQ12, unless the parties have got any particular issues on that point, but we'll work through IQ11 other than dealing with that the extra comments and the condition 3, which we'll get into a little bit more detail on as we go through. No objections from the parties on that document being IQ12. I did circulate the list up to IQ11, which I hope the parties had, and I assume they had no queries on. I will update the list again at the end of today. And I'll provide that just for any comments and points of correction if the parties have a different view on numbering or naming of document and conventions and so on. But that'll be after the inquiry's closed, and it'll be just to correct and make sure the accuracy of the decision letter. In terms of other documents, and Mr. Steele referred to and the additional document that was discussed on day 4 that deals with whether conditions of the previous planning permission could or should be imposed as part of the decision if the appeal were to be allowed. My suggestion is that document's accepted as IQ 13, unless there's any comments that the parties have on that. Okay, I'll take silence as a no. So, and then,
sir, just to clarify that's the document with the list of potential additional conditions.
Yeah, relating to WA 2010-0166. Yeah,
sure.
That's the document. So I'd have that as a separate document, so that'll be IQ 13. Now, my suggestion is that I'll lead the session generally on the conditions list in IQ 11, but it may be the case that I get you, Mr. Steele, to run through the detail of that IQ 13 document before we get into any particular discussion or invite any particular comments on that. But we'll do that after we've done the main conditions list. Now, just in terms of other documents received, obviously, Mr. Banner referred to the helpful submission by the council at this stage of their closing submission for consideration. And my suggestion is that the council's closing submission is accepted as IQ 14. Alongside the closing submission, there are 2 legal judgments upon which the closing submission refers to that have been provided separately, and that's the Samuel Smith versus North Yorkshire Council judgment, and I propose that that's included as IQ 15 for certainty, and also the Baker and others versus Secretary of State judgment, and I suggest that's included as IQ 16. Any comments from the appellant on that particular approach?
No, sir. They're both greenbelt cases, so can easily be dealt with. If it helps you to know for planning today, Mr. Green and I, by serendipity, about our closings are about the same length. So I think his is 17 pages. I hope I'm not revealing any spoilers by letting you know that. And mine's 19 pages. So that's probably about 40 minutes each, I'd have thought, give or take.
Yes, I think I'd allocated up to an hour for both. So my suggestion in terms of timings before you maybe take yourself away to finish off, Mr. Banner, is that we'll after these condition discussions, we'll adjourn for lunch. My suggestion is it can be an extended lunch if we do finish a little bit early, and we'll come back at 2 p.m. and we'll commence at 2 p.m. and then the aim will be to finish around about 4 o'clock at the very latest.
Right. Yes.
Yes.
Very happy with that.
Thank you.
Very happy with that.
I've nothing further from housekeeping unless there's anything that any parties wish to add, so we can get into the main discussion on conditions, and I'll start to lead that. So thank you, Mr. Bannon. Thank you, Mr. Green. If you're going to leave as well, or I'll go into the background, and we'll proceed. In terms of the discussion itself and conduct, very similar to the inquiry. Try not to speak across each other. When I do invite comments, people's already started to do it, but the show of hand is usually helpful, and I'll take the comments on that particular point. If there's no show of hands when I've invited comments, then I'll tend to move on. Please make sure that you do raise your hand in good time to make sure if you've got a particular comment on one of the conditions, because it may not be the case that it may be the case that I don't have any particular questions, having seen the details, and I'm just happy to reflect on it. Now, like I've said throughout the inquiry, this discussion is without prejudice, and it's without prejudice to the cases presented, and participation in this and any comments that are raised in this discussion today should not be taken to that I've made up my mind, nor that does it change the views expressed by parties. It's without prejudice, and it's based on a scenario if I were to allow the appeal, and that's not assured by the fact that these discussions take place, which are normal course of practice. So that's just the disclaimer on the start, and that's obviously so that then we can have frank discussions about the conditions, and it's not implying that it changes any view that's been otherwise expressed. So, for example, if interested parties talk about a highway or parking condition, it's not taken to imply that if you've said that you're not happy with the parking, that it overrides those previous comments raised. I take it that it's talking as a if your views aren't accepted on that particular point, this is what you would like. So I hope that's clear. And are there any particular queries about that approach? Okay, I thank everyone for that. So I hope everyone's got a copy of IQ 11. I'm assuming it was on the inquiry website, and if anyone needs a moment just to pull it up, if that will be helpful to assist the discussion as we go through. I'm just going to run through the conditions basically one by one in terms of where IQ 11 took us from the potential conditions that were suggested in the Statement of Common Ground, the changes that have been made, and obviously whether there's any follow-up comments, follow-up questions from myself, or any comments that any participants today wish to add. So, firstly, starting with potential condition one, there was two scenarios on potential condition one. There's obviously it's based on any ruling that I may reach in my decision in terms of whether acceptance or otherwise of the proposed amendments. So the parties had worked together to propose two separate conditions for either scenario. And the query that I raised with the parties at that stage, which my comment may not be there if the track changes are accepted. So that was the query that the appellant had made, that the comments disappear if my highlighting has been dealt with. But basically, I identified that there was an inconsistency between the two conditions, where insofar as a plan identified as 505 Rev P2, which related to the site access visibility display, was referred to in one of the condition options, but not the other. And it was my view at that stage that I couldn't understand why it was omitted from one rather than the other, because it appeared to be relevant to either scheme, notwithstanding the proposed amendments and any outcome in that particular regard. As a result in IQ 11, the missing reference to that plan was added, so there's a consistency between the two conditions. Now, I don't have any further questions on that part. I'm happy to reflect on that particular change, unless there's any comments on condition 1 that the parties or any interested parties wish to add.
Not from the council, sir.
Just to note from the appellant side, later on in the conditions, pretty sure I haven't got there yet, but we're between us and the council, we agreed, I think it's condition 11 about the visibility displays to be deleted. So I'm just reflecting on that as to whether or not this plan needs to be a agreed plan of the planning permission. But perhaps we can wait until the discussion on the
No, I think I was going to pick it up going back so as not to preempt the discussion. So you've kind of jumped. You kind of no. It shows that you've thought about this particular point, and it was something for me to. That is something for me particularly to reflect upon. We'll get into. We'll talk about the issue that's arisen with the related condition as we move forward. I'm assuming, Councillor Powell, it was in that respect that you wanted to make a comment at this particular point. Are you happy to wait for that?
I'm very happy to wait. I would like to raise a comment on that when we get to it.
No problem. We'll deal with that as we get to it, because obviously there's a more detailed condition on that point. In terms of dealing with condition 1, it was just a matter of consistency. But obviously I'll have to reflect on any comments on the related conditions in light of how that might affect the need for the inclusion of that plan. Okay, if there's not, I can't see any other show of hands, so we'll move on to condition 2. So the revised wording in condition 2 as added in IQ or as changed in IQ 11 was again in response to a comment that I raised in terms of making the implementation clause more precise and time bound. So that there's additions in terms of retaining it for the lifetime of the development in response. Again, I'm happy to reflect on the revised wording of that particular condition, unless the parties or interested parties have any particular comments to add. Like I say, as provided in the statement of common ground, the issue that I raised was that I wasn't sure that the implementation clause was precise enough. But I'm happy to reflect on that revised wording. Obviously, if the appeal were to be allowed, and I do have the discretion to make minor wording changes to conditions, so I can just flag that up if I think they're needed, irrespective at this particular point. So I will reflect on the detailed wording in any case, but obviously in the event that it would not involve any material changes. It would just be refinement of wording if I were to make any changes. But as it stands, I'm just happy to reflect on the particular wording of condition 2. In the absence of any hands or any further comments on condition 2, I'm happy then to move on to condition 3. So condition 3, this is the one where there's some more detailed changes to IQ 11. So what I'll do is I'll provide my initial description of what I consider those changes to be, and then Mr. Steele, maybe you can clarify because your particular changes if my suggestion isn't correct. The changes from IQ 11 are relatively modest in wording context. So basically, the additional changes, and they're in response to the questions that I raised on day 4 in terms of the effect for covering clinical waste, which was a matter that was addressed in Mr. Steele's proof of evidence, but whether the condition actually did what the proof of evidence said that it could do. Now, as far as I'm aware, Mr. Steele's then reflected on that, and then he's come back, and the addition is the condition in IQ 11 says for the excavation and construction activities, and now it just the alternative wording says for the excavation, construction, and operational activities. And based on Mr. Steele considering that then brings into play condition, part C of the condition, in terms of the on-site facilities being required to be approved and then retained by the last sentence for dealing with clinical waste, which wouldn't have been covered if operational activities were not added in that point, because it would be exclusive to the earlier phases of excavation and construction. Is that accurate, Mr. Steele?
Yes, that is.
Thank you. Are there any comments to add from the main parties, or comments from, firstly, main parties? I'll start with the council.
No, sir, we are happy with that suggested change.
Mr. Steele?
Sorry, sir. Yeah, I'm happy with your description of the change. I have no further comments to make other than my as per my track changes.
Thank you. And like I said, it will be added, but obviously needed to explain the changes because those documents aren't before everyone at this particular point. So, Councillor Powell?
Yes, very briefly, sir, I would just like to draw your attention to the comments that have been made in representations regarding the transport of waste from the site to the hotel, and just ask that you consider that in the final wording of this condition.
Thank you. We I will do, Councillor Powell. We may touch upon the transportation details beyond the site in a later discussion on conditions, because I have got a question later on one of the conditions in terms of construction, traffic routing, and matters of enforceability. But I'll deal with that then, and then obviously in terms of the response that I receive, obviously if the appeal were to be allowed and such a condition were imposed, I'd have in mind any comments that I receive on the ability to control traffic movements beyond the site in terms of waste disposal, etc., and construction traffic.
Thank you, sir. I'd also very much appreciate if you consider the movement of waste on the site and the use of the buggies between the cemetery building and the hotel, because the waste collection is from the hotel. That's what's proposed. If you could just consider that, I would appreciate it.
Okay. Thank you, Councillor Powell. Any further comments on condition 3 before we move on to condition 4? No. Okay. In terms of condition 4, and like I said, I'm referring to condition numbers as set out originally in the appendix to the statement of common ground. So this is a condition that in IQ11 is actually proposed to be deleted. It was in response to initial feedback that I provided in terms of avoiding repetition and duplication, because I considered at that particular point of reviewing the original potential conditions that there was the possibility to merge those requirements into condition 9 as part of IQ11. That has been proposed, and we'll move on to condition 9 as we receive it, but that's through the addition of a new subpoint F. And there were some other comments that I had on condition 9 that we can deal with at the same time as discussing that new subpoint F as necessary as move on. But I don't have any comments other than moving on to discuss condition 9, unless there's any particular comments that the council wish to add at this point.
No, sir, I think you've excellently summarised the position. Yeah, we were trying to merge conditions 4 and 9 as suggested. But yeah, happy to touch on it when we come to condition 9.
Anything further from the appellant?
Nothing to add.
Thank you. Anything from interested parties on the removal of condition 4? Thank you. In that case, we'll move on to condition 5. So condition 5 in IQ 11 did include some changes to wording. Most of it was refinement. So bullet points 1 and 7 was include tightening of wording to the action required for the approval of required details. And again, that was in response to my suggestion about precision. That I was concerned that it wasn't quite as precise as it could be. Bullet point 4 for similar reasons, and it also clarifies that it relates to tree protection in the last sentence. Again, suggestions in terms of precision, making sure that it could be enforced and there's no ambiguity in terms of the expectations of that particular clause of the condition. Bullet point 5 was to reflect has a removal of some wording. I think it's all ground level changes associated with this development. And again, the reason for that change rose from a query that I had, that there were already in the approved plans suggested levels. So was it necessary to improve levels again? And that, as a result, that was taken out. Bullet point 8 was remove duplication and avoid repetition, given a separate condition requires an arboricultural method statement and tree protection plan to be submitted and agreed. And then the final sentence, there were changes to make the implementation clause clearer. So again, I don't have any specific questions on those changes, because most of them flow from initial feedback that I provided. Anything further to add from the council?
No, sir. I think we were trying to reflect the suggested or some of your comments. No, we've got no further comment to make.
Thank you, Mr. Steele.
So I believe we're happy with that. James, could you just confirm otherwise?
Sorry.
So I've just asked my colleague just
Yeah,
to
no
confirm
problem.
that.
Yeah, I can confirm. No further comments.
Thank you. Anything, Councillor Powell?
Yes, so just one thing. Obviously, we are going to talk about the conditions in the exeunt permission later, but just in your final consideration of this condition, I would request that you consider that mechanical excavation is now being proposed and mechanical movement is now being proposed, and there were limitations on that placed in the earlier provision. So tree protection areas have to apply during the operation as well as the construction on the site. I would appreciate you just reflecting on that as you finalise the wording, if you're minded to approve this permission.
Thank you, Councillor Powell. Anything further from the council or the appellant on those particular comments?
I just, in terms of the comment about limitations on mechanical movements, I'm not clear there was a condition, but I might be mistaken on the extent plan permission that precisely limit mechanical movement. So it's just an observation. So
Thank you. And I will reflect on that point, and I will review obviously notwithstanding the document IQ 13, so the document that we're going to run through after these conditions in terms of the extant consent 2010 consent. I will review, as I will all documents that were referred to in the inquiry, in full, and if there is anything missing from IQ 13 that I feel would need to be imposed, that'd be something that I would pick up after the inquiry and will be subject to written comments at that particular stage, if we did reach that particular point where the appeal was being allowed and additional conditions were being suggested. So it is a matter of review at this stage, and I do need to reflect on that particular point, and obviously need to need to work through my considerations and the judgments that I reach and consider those particular points before I finalise what conditions would need to be added if the appeal were to be allowed. So we're quite a way off from that, and that may be a process that may follow in a week or two's time if it was necessary. Thank you. Okay. If there's no further comments on condition 5, we'll move on to condition 6. So condition 6, the significant changes made there. I expressed concern in terms of the original wording of the potential condition 6, just in terms of the mechanism by which the approvals and the implementation will take place. And I did suggest a form of wording that is largely replicated in the final sentence, and it's quite a long final sentence of paragraph 2. The only significant change that have risen from the original wording and that suggestion is that the council have suggested a more appropriate time frame rather than 2 weeks as originally specified would be 4 weeks, and I believe that's to allow a sufficient time frame for inspection on site by the tree officer. That's a matter of, obviously I can reflect on that suggestion by the council, but at this point it will be helpful if the council can just clarify that position and then take any comments that there may be on that particular point and the revised wording of paragraph 2 of condition 6. Mr. Collett?
Thank you, sir. I think, yeah, as you have excellently summarised, the changes made to this condition have been to reflect upon your initial comments. And as you've said, the suggestion of the 2 week period changing to 4 is for exactly the reasons that you've suggested. It's in order to be able to receive and review, inspect and respond to the submission. Clearly the council wanting to unreasonably withhold any responses, but we thought that 4 weeks was perhaps a more realistic timescale in that respect. And if I may, sir, there might have been a time period that we hadn't suggested being changed in that condition, and it's the first paragraph of the revised condition where it says that the information will be submitted at least 2 weeks prior to commencement, and I'd perhaps suggest that should also say 4 weeks to correspond with the other 4 week periods.
Yes,
you reflect.
Yes, you preempted a follow-up question that I had. I was letting to see if you were going to pick up on that first.
Yeah.
No, thank you for that, Mr. Collett. Mr. Steele?
So whilst clearly the appellant is comfortable with having such a condition, which essentially is a confirmation that the matters to be agreed under condition, or the previous condition, I think it was 5, now 4, is acceptable. It's just being, I think it'd be remiss of me not to say that obviously that having to submit planning conditions, there is an 8 week statutory timescale, and it's so we already have to do that as part of condition 4, and then there's an additional requirement then to supply something to the council to confirm that detail is being implemented on site, which I said that the appellant is comfortable with, but I think it is reasonable to have a 2 week window upon authority, just to ensure that the proposed development is not unreasonably delayed, and bearing in mind that the time processes prior to that point would also have to be accommodated. But the decision's with you, so obviously, but I'd just like to make that point.
Yes, and you did pick up that. Obviously, I will make that when I talk about wording changes. I will do those consistency checks in terms of the cross-referencing the conditions. So I didn't want to get into too much detail about the numbering. It should be taken as read if conditions are removed. I'll cross-refer. I will reflect on that suggestion. Obviously, there is a difference between the council and the appellant, so I'll review the interaction of those conditions if they were to be imposed, and I'll consider what I believe to be the appropriate timescale if it were to be imposed. Anything further from interested parties before we move on? Okay, moving on to condition 7, which relates to scheme for landscaping, including phasing and timescale. So in terms of condition 7, the changes made to that particular condition, as set out in the statement of common ground, was firstly to reflect the nature of the development, is approval before first use. I think it's quite common with quite a few, so this might come up a few more times as we move on, that the original wording is often a standard condition, which is first occupation for other forms of development. But in this case, obviously, it's been made quite clear in evidence that there's no actual occupation of the building in terms of someone living there. So first use was considered to be more precise in this particular case, and that's reflected in the nature of that change. There were also some associated wording changes to refine the wording of the implementation clause, just to make that more precise in the final paragraph of condition 7. Again, those kind of reflect what I'd suggested, but I'll reflect on the detailed wording. But as a result, don't really have any further questions at this particular point. Happy to just take it away, unless there's any further comments to add from the parties or interested parties for me to consider at this particular point. Council first, please.
No further comments to make, sir.
And that's the same for the appellant. So.
Councillor Powell?
Yes, sir, thank you. I'm very appreciative of the inclusion of guards in point B for the protection of trees from obviously deer and various other things. There is a slight concern within the community, which we have obviously discussed, that I would like you to consider as you finalise the wording for this, which is obviously, how long it will take for any planting to take place, how the existing trees that are part of the landscape will be protected as part of this. And I would just ask that you consider those things, given that the ex-ante proposal is, many years old, as you are aware, and so far only one hedgerow has been planted. And we wouldn't, if you were minded to permit this, we obviously wouldn't want to end up in a similar situation.
Thank you, Councillor Powell. I'll put it back to the council or the appellant whether they've got any comments in terms of the implementation and enforceability and their views on whether the word in the condition could or should be refined to make that more specific and overcome any concerns expressed.
Thank you, sir. And yeah, happy for you to obviously reflect upon Councillor Powell's suggestion. And yeah, I share her concern about wanting to make sure that the planting comes forward in a timely manner. But yeah, I would just reflect on the condition does include phasing and timescale for planting, and then we would expect the appellants to implement in accordance with those approved details.
Thank you, Mr. Collett. Mr. Steele?
Yeah, nothing to add to that, sir.
Thank you. Okay, in that case, if there are no further comments, I'll move on to condition 8. So condition 8 relates to detailing of positions, height, design, materials, and type of all boundary treatments other than landscaping. So again, changes in IQ 11 reflect the nature of the development in terms of the requirement for approval before the first use. So that's very similar to the previous condition, together with associated changes to refine the wording of the implementation clause in the final paragraph, again, based on my suggestion that I had a query about whether it was precise enough to start with in terms of it being first use and then retained at all times. Again, it reflects the proposed wording is seeking to address queries that I had, so I'm happy to. I don't have any further questions because the areas that I asked for alternative wording have been proposed. But are there any particular comments that the council wish to add at this point?
No further comments, sir.
Appellant?
None from the appellant either.
Councillor Powell?
Thank you, sir. Obviously, one of the issues that's been raised during the inquiry is regarding the deer fencing around the boundary. And we welcome the boundary treatment and the inclusion of guards in the earlier condition. Obviously, I would like you to reflect on the community's desire to keep this as a wildlife corridor, which we think can be achieved with the appropriate boundary fencing. And just to ensure that the condition allows for that. Probably haven't phrased that very well, but I'm
no, I understand. No, I understand what you mean, Councillor Powell. Just ask the parties if they've got any particular response to that, whether the condition allows any necessary flexibility for approvals by the council and what the appellant desires. Mr. Collett first.
Thank you, sir. And take on board Councillor Powell's comments. The condition as proposed talks about height, design, materials and type of all proposed boundary treatments, which it doesn't set any specific heights or expectations of materials. And I think the condition is flexible enough to allow Councillor Powell's suggestion to be included if it's appropriate at the relevant time.
It does also, for clarity, it does also mention positions as well.
Sorry, apologies, sir. Yeah.
Right.
Yeah.
Mr. Steele?
So thank you. Yeah, I think if you were minded to want to restrict what I believe is shown on the proposed drawings regarding deer fencing, that then this condition would have to be explicit on that point so that the appellant had an understanding of what they were required to submit to the council, so the details are not unduly withheld through the discharge of condition process.
Yes, I think a common way of doing so would be notwithstanding the details approved in something along the lines of notwithstanding the details approved in condition 1. But I know obviously that would need to be explained in my decision letter if it was necessary why that was imposed and why it met the test of a condition. So I'm happy to reflect on that. If obviously, Mr. Steele, my assumption is that you do not want that, but it's
I'm just saying if you come to that conclusion,
it's within my gift to do so.
Yeah, it would be helpful to everyone to be clear on that. But clearly we've set out our position on the matter at the inquiry and submission documents of why it's acceptable treatment.
Yes, no, it was my suggestion in terms of wording was just a suggestion how it could be achieved. If I was minded and reached a judgment in the case the appeal was allowed, but I considered it necessary to impose a condition that did not approve those details. That is a method that can be used through the condition to require the submission of those details, notwithstanding the plans otherwise approved in condition 1. Thank you.
Thank you.
And any further comments before I move on to condition 9?
Yeah, I think the council's happy for you to reflect on that, sir. And if you think it necessary to include a notwithstanding clause, we'd be happy with that.
Thank you, Mr. Collett. Okay, moving on to condition 9 in that case. So condition 9 is quite a lengthy condition relating to details of surface water drainage with a number of parts. We did touch upon it earlier on in terms of the proposed deletion. I think it was a condition 4. in terms of incorporating, and that was where we referred to the addition of part F in IQ11. That's the principal change in terms of new text, as well as the additional sentence at the end. Because I flagged up in my initial feedback, I thought there was an implementation clause that was missing to make it enforceable. Obviously the details of the revised wording that's been put before me, I'm happy to reflect on it. I don't have any specific further questions beyond my feedback, other than reflecting on those details, but happy to invite comments at this particular point, firstly from the council.
Thank you, sir. Nothing in particular, other than just to say, yeah, we'd obviously reflected on the initial feedback received to try and incorporate some of the suggestions, and to amalgamate condition 4 and condition 9. I don't think anything has been lost in terms of the detail, but brings it all into one place.
Yes, I think my suggestion was just to there seemed to me to be a logic of having it all together, because it seemed to be a related element rather than dividing it in two places, and it obviously implying that there were separate expectations in that respect, which isn't really. It's more precise and enforceable to do it all in one place. Mr. Steele?
Yeah, we're happy with that, sir.
Yes, no comments on this one.
Councillor Powell?
I'm very sorry. So just reflecting on this, and I don't know if you want to leave this to the discussion about the conditions on the EXIAMP proposal, but the buffer zone has a very specific drainage function that supports the protection of the houses at the bottom of the Upper Hale Road, which have had have ongoing flooding issues. And I would just appreciate it if you would reflect on how the management of that buffer zone, which was part of the EXIAMP proposal, and the associated drainage requirements associated with that, need to link into this condition, because I do feel that is not necessarily covered by the current wording.
Okay. Are there any suggestions how you think it might be achieved, or is that going a little bit too far in terms of asking?
I think it's a very difficult one, because the buffer zone was there to obviously create a buffer between the existing properties, manage the drainage issues in that area across the whole site, and the site was approved as a whole. So because this is part of the site, I think that becomes quite difficult. It's outside the boundary of this part of the site, but it's integral to the management of drainage on the site. So I have to be honest with you and say I don't know how you manage that, but I do understand, particularly from the residents of the listed buildings at the bottom of the Upper Hale Road that are affected by the drainage in the buffer zone, that is an ongoing issue that they have. And it feels to me that it's not appropriate for that issue not to be resolved as part of this application. But how you do it, because it's outside the boundary, I don't know. That is the complication of the different boundary lines in this application. Sorry, sir.
No need to be sorry. No, I thank you for your comments. I just invite any response from the council and then the appellant, just in terms of the wording and the conditions and the expectations about the final drainage solutions, and whether that would account for any implications for drainage beyond the site as well as within the site. I'm particularly looking at the storm events and the allowance for creep in terms of the surface water drainage scheme, and whether there's enough flexibility in the condition, giving the council the opportunity in terms of submission from the submission of details to approve those details, whether those issues raised by Councillor Powell would remain in scope. Mr. Collett?
Thank you, sir. I am just thinking for a couple of seconds there.
I'll give you a moment. Yeah. That's no problem. I'm happy to review the wording in that context as well.
Yeah, indeed. Yeah, I do clearly share, Councillor Powell's concern there, and without revisiting any of the discussions that have been had elsewhere in the inquiry about relationship of conditions, there's clearly the extant consent has a different reg line, and areas outside of the outline, outside the reg line for the appeal would still be subject to those conditions and the management associated with it. And clearly, in discharging this condition, I believe that there is enough requirement within that condition to ensure that off-site drainage isn't affected or the situation made worse or dealt
Yes,
with.
I'm looking at Part C as well. There, when
that was where I was looking, sir.
Yeah, because Part C does say a plan showing exceedance flows, and that says during rainfall greater than design events or during blockage, and how property, and it does say on and off site will be protected from increased flood risk.
Apologies, sir. I should have referenced that. That was the bit I was reading myself, and the reference to properties on and off site. That was why I reached the conclusion that there was enough flexibility within the condition to ensure that situation was considered and appropriately dealt with.
Thank you, Mr. Collins. Mr. Steele? I will come back to you, Councillor Powell, on that particular point, but Mr. Steele first.
Yes, just to highlight, as you said, sir, the criteria of that condition, but also to recognise that it was recommended by the local lead flood authority, who had assessed all the submission documents and come to a conclusion this condition would provide what it needs to in terms of drainage and limited and limiting impact and restricting impact in respect to drainage on the site and also outside the site.
Thank you, Mr. Steele. Councillor Powell?
Just to be clear, the submissions that were made as part of this application obviously only cover the red line. The drainage issue that is within the buffer zone is not impacted by the site boundary. It's part of the extant permission. And that's why I'm raising a concern, is that the extant position says that extant permission says that buffer zone has to be maintained, both for drainage and for various planting requirements and various other things. That condition is not currently being enforced. In my opinion, you must form your own opinion, obviously. And there are drainage issues that I am continuously, as the local county councillor, trying to deal with in that area. And I'm just concerned that this is the one opportunity to resolve that issue. But I do accept that it's outside the red line boundary, but it's inside the ownership of the appellant. And I don't know whether it can be dealt with in that way. Could be to do with land ownership. I guess my primary concern is the site's already been split at least twice since the extant permission was granted. There is nothing to say it won't be split again. And then the management of that buffer zone becomes even more problematic. And the associated drainage in that buffer zone. There is no easy answer here because of the way the application site has been split and the extant position has been split. And I recognise that, and I don't envy you the job, but I'm just raising the concern. Sorry,
yes,
sir.
No. I reflect on that, Councillor Powell. Thank you. Anything further to add from the council, or the appellant are happy for me to reflect on it and to consider it, having reviewed the details referred to in terms of the 2010 extant permission?
I've got nothing more to add, so happy for you to reflect.
I need to say that enforcement issues are separate and not relevant to this particular application.
Thank you. Unless there's any further comments to add, in that case, we'll move on to condition 10. So condition 10, it's a related condition in terms of verification report for the drainage arrangements. The suggestion on this particular condition, because it is related and it's necessary that it will be separate, was just similar to previous comments, was the reflecting the nature of development, making sure it was precise in terms of approval of details before first use. That some proposed wording has been suggested in IQ11 in that context, which obviously seeks to address that query. And I don't have any further questions. I'm happy to reflect on that proposed wording unless there's any comments that parties have in that particular regard.
No further comments from me, sir.
Mr. Steele?
No, none from me.
There's no hands from interested parties, so I assume content to move on. So in that case, we'll move on to condition 11, potential condition 11. So this we did refer to this briefly. This is the site access visibility display condition, and Mr. Steele referred to condition 1 in that respect in terms of the changes that were made and whether those plans should be included in the list of the particular plan in question, which is the final one on the list in condition 1. The reason being is that the following my query, the query just to assist those, I think it is available on IQ11. I think it's been replicated, my particular comment, but just for certainty, the query that I had related to the existing site access onto All Hale Road, whether the land was actually in the control of the appellant and therefore was enforceable in that respect. And there's also questions about its necessity, given the site access exists, to include such a condition. Responses were received from both the appellant and the council, and they can be seen again in IQ11. And the agreement between the parties was to delete the condition for those very reasons, assumingly it's land ownership, it's not capable of control by a condition, and the fact that it's not the formation of a new access, there is an existing access there, and the presumption that it didn't require further mitigation to avoid access highway safety issues for those using the access, and obviously pedestrians using the adjacent footway that crosses over the access point. My assumption is that I've summarised that position accurately. Of the council, any points of clarification or anything further to add at this particular point?
Thank you, sir. No, I think you have summarised it accurately, and having reviewed the comments and the suggestions, and then the interrelationship with the extant consent in terms of the access and the fact that it is an existing access, with the reasoning behind the suggestion that condition is deleted.
Mr. Steele, anything further?
Nothing to add, sir.
Councillor Powell?
Yes, sir. I would point out that it was a condition that was requested by the Highways Authority. And the reason the condition was requested by the Highways Authority is I've only been a councillor since May 21, and that hedge and the access around that area has been an issue on a number of occasions just in my tenure. So the reason it was requested is because the maintenance of that particular hedge has been an issue historically in terms of visibility, and particularly in terms of pedestrian access. And that's why the condition was requested by the Highways Authority. I understand that Waverley Borough Council, as the planning authority, has a different view, as does the appellant. But as the local county councillor, that's the reason that condition was requested by the Highways Authority, because of issues within the last 4 years. I would just like you to consider that. I'm not saying. Yeah.
Thank you, Councillor Powell. Just as a point of clarification, and if the parties can assist me, do we know who's responsible for the maintenance of that hedge?
The appellant is responsible for that, although at this point that might be Amman Gardens, I'm not sure. It was part of the Exeant permission outline boundary. Whose responsibility it is today, I couldn't tell you because I don't know how the land was specifically split.
Thank you. Mr. Steele, can you help me on that particular point?
Yeah, so the access point is within our red line and so is in control of the pattern. In terms of the specifics of the hedge, I can't answer that question precisely with the information I have before me, sir. What I would add is that I think it's being said it is an existing access already. The appellant through their operation of the site will be able to manage any hedge that's in their ownership accordingly. I would add to part of your summary at the start of the discussion, sir, just to say that because the land outside the red line immediately on that point is highway land, if you were to come to a different conclusion, then then in my experience the local planning authority would have some certainty that it could be controlled as such. So I don't think that's a determining matter, but like we've said in the comments, it is an existing access which is serving existing uses.
Yes, that's why I asked the question, really, because it does appear to be outside the control of the appellant to a certain degree in terms of the plan that's been provided, and maybe outside the ownership and control. But the highway, there are controls under highway legislation that would allow vegetation clearance if it's obstructing adopted highway. That would be my understanding of the situation. Unless any parties wish to pick me up and clarify me on that legal point. Councillor Powell, anything further, and then I'll take the council's comment.
No, you're absolutely right. Letters are issued to the landowner, have been issued, and on one occasion the hedge was cut by the council and back charged to the owner. Who the owner was at that point in time, I can't tell you.
Thank you. Anything further, Mr. Collett, on behalf of the council?
No, I don't think so. So.
Thank you. There's no other hands, so I'm happy to move on in that case. Apologies if I can just hold one moment. I've actually got a window in front of me. I can just notice that the sun started to poke through, and I'm getting light across my head. So I'll just move that. Right. Hopefully that's a bit more helpful. Just close the blinds. Okay, so moving on to condition 12. So condition 12, just for certainty, relates to space being laid out within the site for vehicles to be parked and vehicles to turn so that they may enter and leave in forward gear. The changes in IQ11 again, just reflect the nature of development in terms of the requirement for approval of details before first use. And I note those suggested changes following the query that I raised, similarly to a number of other conditions. I'm content to reflect on that revised wording and to look at the precision of the condition accordingly, if it were necessary to be imposed if the appeal were allowed after the inquiry, unless there's any particular comments that anyone wishes to add at this stage. Nothing further from the council?
No, sir.
Mr. Steele?
No, sir.
There's no hands, nothing from interested parties on that particular condition. In that case, we'll move on to condition 13. I think that's a very, very similar situation. So again, with the condition, just for certainty, relates to detailed and secure cycle parking facilities for visitors to be submitted and approved in writing by the local planning authority. The principal changes again are to clarify in terms of first use, very similar to the previous approach in condition 12. Again, happy to take a similar approach to this condition, take it away, unless there's any particular comments to add.
I'm happy with that, sir.
Mr. Steele?
No, that's fine, sir. Thank you.
There's no hands from interested parties, so I assume there's no one wishing to comment. So Happy to move on to condition 14 in that case. So condition 14 relates to submission of a travel plan, and there were changes in this particular response just in terms of the timing and submission of the approval of the travel plan. I think the original condition as written included a time period after, I think it was first occupation. Obviously, there's a correction there in terms of first use. But I did raise a query as obviously in terms of the necessity for the condition, if it were required, was there a specific reason for a delay in the timescale for the submission of the travel plan, or should it just be similar to others as first use? The revised wording that has come back has just reverted to a similar approach to prior condition, it being prior to the first use. A travel plan should be submitted. Again, happy to reflect on that approach and the revised wording, subject to any minor wording tweaks that I may need just in terms of precision, unless there's any comments to add. So anything from the council first?
No, sir. Just to give you a bit of background, I have taken instruction on why the 3-month had been included originally, and that had been to enable the development to have operated and to understand how the development operated before a final travel plan was approved. On reflection, I agree with the suggested change to a first use, because a travel plan can include a review mechanism in any event. I did just wonder, sir, just for clarity of the first few words about sort of rejigging to perhaps prior to first use of the development, a travel plan shall be submitted to and approved.
Yes, I think that's why I said I'd said that about minor wording changes. That's something I would be likely to change. Just for.
I would just add. Apologies for cutting across you, sir.
No, that's fine.
I would just add. I may want to revisit that condition depending on some of the discussion about disabled parking.
Okay. The only thing that I would want to pick up with you on that particular point, just in terms of the review mechanism, is just whether the final sentence, in light of the possibility of review, because I understand the explanation that to have the possibility to have a review mechanism to reflect on how the use will be operating can be quite sensible to allow the travel plan to be updated. But obviously, the final sentence of the condition says in accordance with the approved details. For certainty, would it need for want of a better word, a tailpiece to allow, unless amendments are otherwise agreed by the local planning authority, to give that flexibility for an updated version? Because otherwise, it could be argued that there's need to lock into the original travel plan, which might undermine any review mechanism that's actually in an unintentional breach of the condition, shall we say?
No, indeed, and yeah, I agree with you, sir. Happy for you to reflect on that wording.
Mr. Steele, obviously there isn't a suggestion to the word in there. Is there anything further from you or your colleague, Mr. Callaway, in terms of the use of that flexibility? Obviously, it's something that it does happen in terms of allowing amendments to details. It's generally used sparingly to circumstances where it's actually necessary to allow those further amendments to things that have been agreed. But I've heard what Mr. Collett's suggested on behalf of the council on the reason for the condition. Have you got any comments or suggestions in that?
Yeah, I was just reflecting on this, on the review mechanism point. As a planner, I'm thinking about whether it's proportionate to the scale of the development proposed, and particularly given the nature and the information that's been provided as part of the planning application up front, in terms of how the use of the building is going to operate, and the way in which the trust have described how attendees, etc., are managed via the appropriate means as set out in the highway evidence. So I think it's just a point to say, is a review strictly necessary for what is proposed here based on all the highways evidence presented and the impact of the scheme?
Well, I think in terms of the condition as written, I don't think there's anything in the condition as written that suggests a mandatory review mechanism. I think what the council was suggesting that they may expect it, and that presumably that's based on the details to be submitted and approved.
Right. Okay.
If the council, for example, weren't 100% convinced that the measures that were suggested would work, but the appellant was insistent that, for example, it would, because and obviously the operation would prove that would be something that may include as a result. And I'm talking scenarios, but that may result in the inclusion of a review mechanism to say, okay, if you're not 100% satisfied, we can review it in 3 months. And then, in terms of the discussed tailpiece condition, that then would stop that unintentional breach if those details were in. I don't think I was suggesting, and it wasn't my interpretation that the council was suggesting that the condition includes a mandatory review.
Okay.
It's the option for a review to be included potentially at the appellant's discretion if the details couldn't otherwise be agreed in terms of whether they were satisfactory or not at that particular stage, and needed to be borne out in terms of whether any implications unforeseen occurred at that particular juncture.
Sure. Okay. Well, with that clarification, if that was the intention of the council, then yeah, no comments on that have been in principle. But yeah, a mandatory review mechanism has been something I wouldn't suggest.
Yeah, so I wasn't suggesting them including mandatory in there. It's a matter that be agreed with the council. Now, Councillor Powell, I've noted your hand up. I'll go back to the council first, and then obviously anything picked up after I've heard the council response. Mr. Collett.
Thank you, sir. I just wanted to clarify that, yeah, I wasn't suggesting a mandatory review process. It was just the ability for a review, if appropriate, at condition discharge stage, if that puts other people's minds at rest.
Councillor Powell. Thank you, Mr. Collett.
Thank you, sir. I would just ask that you reflect when you are considering the final wording of this condition, the discussion we had around conflicting use of the car park and the use of marshals and how they may be used, and also the impact of any decision that you choose to make regarding the provision of the church car park and the impact that would have on the necessity for marshalling to protect the highway safety that is reflected in the representations that have been made by the Highway Authority, particularly in some of the comments they made in their the conditions and the reasons for those conditions.
Thank you. I can assure you I will reflect on what I've heard, and obviously that it's without prejudice to any discussion. Just in returning to the condition itself, do you think there are any shortcomings or any omissions from that condition that you think could be could be included that would address some of the concerns that you may have, notwithstanding the principal points that you've raised, just in terms of the implementation of such a condition in a scenario if the appeal were to be allowed?
I think it would be appropriate to consider referencing LTP4, which is referenced in the Highway Authority's submissions to you. And I think that it would be appropriate for you to consider how the conflicting use is going to be managed, given that the ex-ante permission has been now separated into multiple land uses. But that's obviously for you to consider, sir. I'm not implying one way or the other.
Thank you. Just put it back firstly to the council whether they consider there's enough flexibility in the wording to deal with those matters as part of the travel plan, or whether it need in the council's view it needs to be specified specifically.
I think, yeah, taking on board, yeah, Councillor Powell's point, I'd be happy for you to reflect, sir, on the need for marshalling and car park control to be included either within that or a new separate condition with some kind of car park management plan, if that was considered more appropriate, in case it became too confusing, in a travel plan which typically considers the way in which people travel to the site.
Yes. What I may ask the parties to do is, it's likely that after the inquiry closed, that I do give a deadline of, say, next Friday, that if the parties review the conditions in light of these discussions working together, and wish to make any suggested agreed wording changes to put before me, that they do so in that, rather than me concocting material changes to conditions that may come as a surprise to the parties. The suggestion is that the parties put the proposed wording to me, and then I consider that in the event that the appeal were allowed, and then only in the circumstances if I were to grant planning permission, and via allowing the appeal, imposing conditions, and I consider it necessary to make material changes that we may have discussed today, but aren't reflected in the proposed wording, that I then do give the appellant the opportunity to have final comments on any suggestions that I make that are material. Does that sound appropriate, Mr. Steele?
Yes, it does, sir. Depending on those discussions, there still may be areas of disagreement between the parties, and we just take those comments away and make a decision on that basis. I assume. I'm just mindful of what I've heard from Councillor Hale. In terms of how you clarified about a review mechanism, but then to talk about how the whole site operates, and potentially, the appellant only has control of the red line. So
yes, no, I understand.
To be that balance in what these conditions can.
Yeah, I understand. I just think it. Obviously, we've discussed these particular points, but it's just a case of the parties reflecting on the conditions to just see if there are elements that they consider could be added, if or consider it necessary to be added following these discussions, that would make them more precise in terms of the expectations, and if those were considered necessary to put them to me. Like you say, there may still be dispute between the parties over that. For example, the council, taking account of the comments, may have suggestions that the appellant doesn't wish to be included, and obviously they can be put to me as in a similar manner to what we've seen in IQ 11, to say these are not agreed and these are the respective positions. So it may be the case that the appellant wishes for it to remain the same, or there's minor tweaks the appellant suggests, in contrast to the council having different wording. And then at least I can reflect on that, and if I were to allow the appeal, grant planning permission, and impose the related conditions, I can explain my reasoning for what's included in that condition as part of my decision.
Thank you, sir.
Thank you. We've no hands up at this particular point, so I'm assuming parties are happy to move on. Just to clarify, I will confirm that typically that deadline would be the Friday after the close of the inquiry. So the submission, and it will be specific to submission of revised conditions, and obviously without prejudice to the position of any party, or implying that a decision's been made or the outcome is to allow it without prejudice. But that typically would be Friday the 24th of January. That would be the deadline, 5 p.m. January 24th. So I'll make a note of that. And that would obviously that would typically take the form of a submission to my case officer by that time, and I'll take that into account. The receipt of that document would be noted on the appeal decision as a post-decision document, and it should also be uploaded to the inquiry website as well, for transparency, so everyone can see what the final submissions are. There wouldn't be an opportunity for any final written comments at that stage, because the appellant has the final word in terms of what what they would be happy to accept. It would only be in the circumstances were I to make what I consider to be a material change. If I were to allow the appeal and alter a condition significantly or add a condition that would otherwise come as a surprise, that I would invite the comments from parties on that, and that would be communicated to the parties specifically. Okay. Moving on in that case to condition number 15. So for certainty, condition number 15, as referred to, related to the 2 disabled car parking spaces, and this was a this condition is in dispute between the appellant and the council, as previously mentioned. Mr. Tilbury, you've got your hand up at this particular point. Sorry, you're on mute. I think you just need to mute yourself.
Just to so I may have a comment that I want to make, if appropriate, after the appellant and the council have discussed the point.
Condition 15.
Yes.
Yeah, no problem. Keep your hand up. You just, it was probably just early that I thought it was. I'd moved on too quickly. But no, keep your hand up now. It's fine. I know what it's for, so that's absolutely fine. I'll start again.
It was a preemptive hand. Sorry, sir.
No, that's fine. Condition 15 in dispute. It's related to the disabled car parking spaces that we actually referred to during day 4. I did ask questions of Mr. Vet as part of the inspector questions on this particular point. The changes in IQ 11 specifically, with that talking about first occupation. So does seem to be a wording change that's maybe needed. If it were to be imposed, I think there's still a first occupied in there, so I would look to correct that just for consistency, but I don't think that that's necessarily a point that needs to be discussed in detail unless parties have any particular comments. I'm happy to otherwise reflect on Mr. Vet's contribution without asking further questions myself, because the questions I had were answered by Mr. Vet. I'm happy to reflect, but I'm happy to take any contribution you may have at this point, Mr. Tilbury, before we then give the opportunity for the council and the appellant to comment.
Well, I was just going to comment, sir, on the logic, as it were, of the appellant's position, which is to suggest that we don't need this condition because that's not how we're going to do things. But that's not the way the planning condition works in relation to this, to the consent. It's a matter of placing a condition in relation to the use of the site, not in relation to the way that the appellant from time to time goes about their business. And that's the purpose of the condition, is to make sure the disabled parking spaces are there. The note that I have from the appellant is saying it's not necessary because basically disabled people will be treated in a particular way. Well, that might be the case, but that doesn't, as it were, run with the land in that sense. So, with great respect, I would say there is no logic to the appellant's resistance to that condition.
Thank you, Mr. Tilbury. I'll go to Councillor Powell as well, so then the council and the appellant can pick up any comments together, rather than potentially going round in circles and addressing multiple points in different orders. Councillor Powell.
Thank you, sir. Just to be clear, one of the roles I have as a county councillor is to stand up for the rights of disabled people and also for their independence. Disabled spaces are provided to allow wheelchair users. One of my best friends is a wheelchair user who has no legs, and she gets herself around in her own car. She needs the width of a disabled space to be able to get from the driving position into her wheelchair, something she does every single day, multiple times a day, which she can only do in the width of a disabled space. So I would just ask you to reflect on the purpose of disabled spaces and to reflect on what Mr. Tilby has also said, in the fact that this is not a planning permission that is specific to the Ismaili community. It is a planning permission that is more generic than that. And I would certainly want you to reflect on the need for disabled people having their independence. That is their right. Thank you, sir.
Thank you, Councillor Hall. Mr. Collett first, and then allow Mr. Steele to respond to anything on that particular point. 2 points that have been raised. Mr. Collett.
Thank you, sir. I think the council's position is set out in IQ 11, and I would just pick up on Councillor Powell's position, which I completely support, about the independence and equality for disabled people, and particularly refer you, sir, to the council's parking standards, which is CD 8.1, and the reference is in the council's comments in relation to this condition, the relevant section that does talk about a requirement for non-residential development to deliver disabled parking to a certain standard and to a certain provision. And we see no reason why this development shouldn't provide disabled parking in accordance with the standards. And I would also just add that we've heard during the inquiry and in evidence information about how the site would operate, but there is actually no condition or Section 106 obligation in place that would require the site to be operated in that manner. And the reason, sir, I asked to potentially defer to come back to the previous condition on travel plans and our discussion there was, if following your reflection you don't consider that the disabled parking is necessary, there does need to be some mechanism to secure appropriate provision for disabled people to park and move around the site. But I see that very much as a backup, not as certainly the preferable situation, which will be to provide dedicated disabled parking in accordance with parking standards.
And just in terms of how that would be accommodated in the context of the approved plan, obviously I had a previous discussion earlier in this session with Mr. Steele about the notwithstanding clause, presumably because the plans include a parking layout, there would need to be some revisions to this proposed condition that probably isn't in there as well in terms of a notwithstanding clause. So for that reason, obviously what we've said about submission of suggested changes, that's something that the council may wish to reflect upon if there remains dispute for that submission for next Friday, is whether for precision then there would need to be changes to what the council is proposing to me. Mr. Steele.
Thank you, sir. I don't really want to add anything more to the justification of the appellant's permission. To add on what Mal Devet said the other day, so I think that it's clear from that. Now, I think there's no issue from the appellant in providing disabled space within the car park. I think it's the condition that requires it shall be located no more than 50 meters from the building. That is the main issue from the appellant's side. But so I appreciate what you've just said regarding that with respect to Rob Collett's point, and so I don't have anything more to add on the appellant's case in that respect.
No, noted. Thank you, Mr. Steele. And obviously, like I said, there's the opportunity by next Friday to submit any revised wording if there's a reflecting on that position. Obviously, if the appellant chooses not to, that's entirely fine. It does appear that if there remains dispute and the council has its position that there would need to be some revisions to make sure that the interaction between condition 1 was accurately reflected, because obviously there is a proposed car parking layout in either scenario for whether the amendments are accepted or not. and wouldn't want an unintentional conflict between the conditions if such a condition were to be imposed in the event that the appeal were to be allowed. That's sometimes something that you need to reflect, that sometimes can happen and inspectors do have to resolve, but it's better generally that parties pick up on where those consistency matters might occur as well.
So can I just confirm you in terms of my statement there, in terms of the justification provided by Mount Vet, I confirm you heard that the other day at the inquiry?
Yes.
Okay.
Yes, I heard the justification from Mr. Vet, and I have taken that in. I will take that into account. And like I said, the discussion that we're having here is without prejudice, and it seems to me that there is a difference remaining between the council and the appellant. So there is an opportunity there for revisions if the dispute remains. And that can be submitted to me by next Friday. So it needs to be clear from the appellant what the appellant is willing to accept, if anything. And obviously the council needs to make sure that any consistency issues are overcome. Thank you. There's no hands remaining on this particular point, so I believe it appears that the parties are happy for me to reflect on that and review anything that's received following these discussions. So in that case, we'll move on to condition 16. So condition 16 for certainty relates to the requirement for an acoustic report. I did provide some comments in terms of the acoustic report. It's specific to the electricity substation that forms part of the proposal. Obviously, the substation is located in different locations, but that doesn't really matter to my mind for the purposes of the wording of the condition, because there is a substation in both scenarios, whether it's the proposed amendments or the plans upon which the council made its decision before the appeal. But the question that I had and the query that I'd raised was whether there should be a cross-reference to the subsequent condition 17, which includes noise associated with plant machinery and air source heat pumps, which we'll go on to discuss next. The response, the appellant considered the condition isn't necessary because it is covered by condition 17. That was the response as part of IQ 11, whereas the council suggested, although there does appear to be some commonality, and I'm paraphrasing, between noise issues, the council considered they relate to different assessments, and so a cross-reference isn't appropriate. And the substation may not be delivered at the same time as the building, so they consider that there's difficulties of only having one condition in that particular circumstances. Obviously, that remains a point of dispute whether condition 16 is necessary as a result of IQ 11. So firstly, I'll go to the council to explain their position just for certainty and make sure that I've reflected accurately, and then allow the appellant the opportunity to explain their position. Mr. Collett.
Thank you. So I think you have excellently summarised the position. Yeah, the council's view is that the two noise conditions relate to different matters with different criteria, and potentially different delivery time periods. So we felt, having reflected the comments, that it wouldn't be appropriate to amalgamate or cross-refer the two conditions because they're relating to different items. Clearly happy for you to reflect on those thoughts and reach your own conclusions.
Thank you, Mr. Collett. Mr. Steele or Mr. Calloway, whoever's best placed to deal with this point.
Thank you, sir. I think that there is an opportunity to amalgamate the conditions, and that may need some tweak of the wording. But I acknowledge we did previously agree to the two separate conditions before, and obviously we're just responding to your points of clarification. But I don't have anything further to add.
Yes, so you agreed to it. So if it was considered necessary in light of the comments, you'd be happy to return to that agreement.
Yeah.
Thank you. Well, like I said, the appellate can confirm its position by next Friday. So there's no need to commit. It might be something that you go away with. If you think there's some revised wording that could deal with it, and you come to an agreement with the council, fine. If there's still dispute and you feel that there's revised wording that might achieve it, you can put that before me in the respective positions, and I can deal with them accordingly, reflecting upon this particular discussion.
Thank you, sir.
Okay. There don't seem to be any hands from interested parties, so I'll give one moment, and if none arise, I'll move on to condition 17. So it is broadly related. I'm not going to repeat the discussion that we've just had there, because it's not necessary. Obviously, I'll leave that hanging in the air for the parties to reflect upon, and if it's necessary to propose something alternative to me in that light, in light of condition 16 and its relationship to condition 17, then they can do so. But in terms of the specific changes in IQ 11 to condition 17, the query that I raised was just regarding the precision of the implementation clause. It didn't seem like there was a time-bound element to it in terms of how it would be controlled. So the ambiguity could make the enforceability difficult if it wasn't clear when the controls would occur, when they would cease, if they would cease at all. So in response to that, the parties are putting IQ 12 to me just the addition of some wording. So it shall be controlled for the lifetime of the development. Again, it's in response to a query that I had. I'm happy to take that suggestion away and reflect on it, unless there's any comments that the parties wish to add. Anything from the council?
No further comments, sir.
Mr. Steele?
No comment.
There's no show of hands, so I'm assuming there's no comments from interested parties on that particular point. In that case, I'll move on to condition number 18. Condition number 18 for certainty relates to the use of the pavilion buildings and the timing of the use of the buildings. And I did raise a query in previous days of the inquiry, just in terms of the use. I think it might have been on day 4, in terms of the timings, and obviously the timings there in terms of 10 a.m. and 4 p.m. on Tuesdays, Thursdays, and Saturdays are specific. We did hear comments as well from interested parties in terms of the conditions and the interactions with previous permissions, which I will reflect upon, subject to any discussion that we have in a moment on IQ 13 when we move on to that document. The response that I received was I received during the inquiry is broadly similar to what's in IQ 11. So the query that I had was largely what I said in the inquiry, which was what would happen if funerals were scheduled at 10 a.m. and typically people arrive for funerals earlier. So would the condition actually work in that context? The appellant suggested that the suggestion is to keep the trips within peak times, that the funerals will be arranged accordingly, so the start time wouldn't be 10 a.m. So that the condition will be met. So there seemingly is an awareness of the need to comply with the condition, and that obviously the funeral timings then would have to be arranged at appropriate time to ensure that those movements are managed. There was some suggestion from the council just in terms of happy with the wording being acceptable, including in advance rather than prior to that specific wording in the condition itself. So that's to do with the tail piece, where it allows sort of variation by the council if there were prior agreement, and the council may explain what circumstances that's intended to cover, or the appellant may do so as well. So I will invite those comments first. I have noted that you've got your hand up, Mr. Tilbury, so I will come to you after you've heard what the council and the appellant's got to say, and then I'll give the appellant the final word after you've had a comment. So I'll start with Mr. Collett.
So, yeah, thank you. Yeah, as you correctly said, there has been a minor change to the first part of the condition, which I won't comment further on. And yeah, the second part of the condition that starts, this excludes the arrival of hearse volunteers in preparation for the funeral and those visiting graves. If I can firstly just refer to those visiting graves, and we'll talk about it later in terms of IQ 13. People visiting graves, that there are separate conditions relating to those people, and control when they can and can't access the site. But the main reason for this condition, as you have summarised, is to control the timing of the funeral ceremonies, and what we didn't want to see restricted we're really some minor or more minor movement, and we've heard extensively during the inquiry about the Gusel process, and the condition isn't seeking to restrict when bodies can be moved to the building and those processes taking place. It is really about controlling when the majority of people would be accessing the site, which is to attend the funeral ceremony itself.
Thank you, Mr. Collett. Mr. Steele.
Thank you, sir. Yes, I've got no further comments to add.
Thank you, Mr. Tilbury.
So if I can start with the sort of the big point that we'd like to raise, if we may, which is the question, and notwithstanding the comments I made about the disabled parking, is whether the town council suggestion is that there might be a case, depending on the reasoning that you apply, were you to allow this appeal, for restricting the permission to the Ishmaeli community specifically. Now, I know the council have not asked for that. From the town council's point of view, we don't quite know why the borough council hasn't asked for that, because we think it would be entirely reasonable, depending on the logic of your reasoning, were you to allow the appeal. I fully accept that if you were just to conclude that a building of this nature, regardless of its regardless of the community that made use of it, was acceptable, then there'd be no case for restricting the condition. But if you were to give such significant weight to the submissions that the Ishmaeli community requires this building, such that were to be the difference between you allowing the appeal and not allowing the appeal, then the logic of that would be that it is the use by that community which is the difference here. And that were it to be used in the future, were the site, as we must accept is possible, to be disposed of after consent has been issued to a different community, for a different, or back to the original owner or whatever, then that essential component of the reasoning for granting consent would be lost. So I fully accept that it depends upon the basis of your reasoning as to whether or not there would be a case for considering it, but there might be, and we would ask you to bear that in mind in doing so. It is not in any way meant to be detrimental to the Ishmaeli community to suggest such a condition or the restriction, because of course, you know, that it would ensure that nobody except them was able to sort of make use of the building, and it would limit the opportunity for any subsequent disagreement, perhaps, over whether or not actually it was a consent that the community wanted to exercise. So we would just ask you to consider whether there might be a case for the restriction to the Ishmaeli community itself, depending upon the judgment that the basis of the judgment that you reach. So that's our first comment. Secondly, just on the wording of the condition as we've got it, as I've got it in front of me, which is printed off the inquiry website this morning. I mean, it's not very well worded in my humble opinion, in the sense that if it is the case that the appellant is suggesting that funerals won't take place at 10 o'clock, well, the condition doesn't prohibit that. I fully accept the appellant's intention, but again, if the question is, what would the condition on the consent actually say? And the condition would say that a funeral can take place on the dot of 10 o'clock. And no restriction on that. So that's problematic as it's worded. Being very pedantic, one might suggest that the way the wording of the condition works at the moment is that whilst the time limits for funerals are set for Tuesday, Thursday, and Saturday, there is no actual exclusion on funerals taking place on any other day of the week or within any other time. So effectively, what that condition, the way the wording is at the moment, it could well be interpreted as to limit the timing of funerals on Tuesdays, Thursdays, and Saturdays, but to imply that there is no time restriction on funerals taking place on any other day, because there's nothing to say that funerals can't take place on any other day of the week. That is easily corrected just by inserting, a couple of words to make it clear that the intention of the condition is that no funeral should take place except on a Tuesday, Thursday, or Saturday. If that is the intention of the condition, it's ambiguity that's easily avoided. And finally, just the phrase "those visiting graves" is very ambiguous. A cemetery is a place where people visit graves. That's what they do at any time, any reasonable time. So the introduction of that phrase into the condition doesn't really, I'm not sure it really helps very much, and actually allows for ambiguity. The reason I mentioned
sorry, Mr. Tilbury, just before you carry on, just in terms of visiting graves, just picking up that particular point. Obviously, there was reference to restrictions on the previous 2010 permission, and we'll potentially get into that in terms of visitors outside the hours of daylight. There might be the possibility for the need, notwithstanding any further discussion, for some reflection on the interaction of that element with any condition were it needed from the 2010 permission.
Yes, sir. And I think what that clause is trying to do is clearly to make it clear that this condition is not meant to exclude the possibility or the necessity of those who are conducting funeral rites prior to the funeral taking place from being present. And that's fully understood, sir. It's the ambiguity in the phrase or the lack of clarity about that, which I think is problematic. I think it would be much more helpful if we could find, if it were possible to find words that made it very clear. So that, and the reason I said mentioning it is that I think it would be helpful if there was absolutely no ambiguity on and no doubt, no reason for dispute or subsequent dispute around who is entitled, as it were, within that condition to be on site preparing for the funeral and so on. I think visiting graves doesn't really help us very much. Something that made it clear that there was no intention to exclude those members of the community who were preparing the burial, conducting the burial, the rituals in advance of burial, that would be almost more helpful in making it clear to whom that particular condition was supposed to not be applying to, if you follow the logic.
Yes, I do note it, and I'll give the council an opportunity just to offer any comments before then on what you've raised on those 3 points, and then I'll allow the appellant just to respond to them. Thank you, Mr. Tilbury. Mr. Collett first. Anything to add in response?
Yeah, thank you. So yeah, there was quite a lot there from Mr. Tilbury. So hopefully I've noted it all down. If I can perhaps come to the restriction point first, in terms of when funerals can and can't take place. The suggested wording says that funerals shall not be carried out except between the hours of 10 a.m. and 4 p.m. Tuesdays, Thursdays, and Saturdays. I felt that was precise, that funerals shouldn't be held at any other time. But I would be happy, sir, for you to reflect on that and to make absolutely certain, some wording like, and at no other time, perhaps after that, to make it absolutely explicit.
Well, like I say, I'll allow the council to make its own suggestions to reflect on if there are elements to improve by next Friday.
Yeah. In terms of those visiting graves, and I think that will probably become clearer when we start talking about IQ 13. That this condition isn't meant to be affecting the way in which people visiting the graveside outside of a funeral ceremony takes place, and there is a separate suggested condition to be duplicated in a suggested amended format from the 2010 consent that would control and identify when people visiting the graveside can and can't attend, which relates to daylight hours, and we'll come on to that shortly, sir.
Just on that particular point, and obviously before the appellant has the opportunity to respond, I'm just thinking this condition relates to the use of the pavilion building hereby permitted and funerals. Yeah. Is the element of visiting graves necessary at all in that context? If it's a separate condition.
Indeed, sir. Yeah, I'd be happy for you to delete that. Obviously, on the understanding that, and it is clarified in the condition that we'll come on to in IQ 13, that people attending the funeral can, obviously that those permitted, can then attend the graveside as part of that ceremony. And we're not wanting to restrict the ability for people to do that. But I totally take the point. This is a condition relating to the pavilion building itself and not to any other matter.
Yes, it does. It's on reflection and having heard what's said, it does seem, it seems logical to me that there are exceptions based on the evidence that I've heard in terms of the arrival of the hearse and volunteers participating in the preparation for the funeral, which we've obviously heard. But the visiting graves element, particularly in light of IQ 13 now, that is probably a matter for all parties to reflect upon, and noting Mr. Tilbury's comments. Mr. Steele?
Yeah.
Oh, sorry, Mr. Collett. Did you have anything?
Sorry, there was one.
There was 3 points, yes. So you've got 2. So sorry, Mr. Steele. I'll let you hang fire a minute. Collett.
Yeah, and that was, I think it's probably, if it was taken forward, would be a different or a separate condition. The council aren't proposing a condition that would seek to restrict the use of the building or the land to the Ismaili community only. Obviously, we have made submissions, and I recall from my cross-examination my comments about that the permission wouldn't restrict the building to only the Ismaili community use. And I think it was Mr. Banner, although forgive me if I'm wrong, that said, it would be very unlikely that wouldn't happen.
I think there was. I have heard evidence earlier in the inquiry where the intention is obviously the Ismaili community. There are marriages within
sure.
with people of other faith, and there would be an intention for ceremonies in that. There could be intention for ceremonies in that respect to be undertaken. So I will have that in mind.
Yeah, and yeah, as I said, it isn't the council's position that we are suggesting or requesting such a condition. I'm happy to leave it to your reflection, sir, but I would refer you to, and as you will be looking at, the PPG in relation to the use of conditions, where there are comments made or guidance provided in terms of conditions that limit a permission to a user. And that does seek to resist such conditions, particularly, and I have got it in front of me here, and it's paragraph 15 of the use of conditions part of the PPG, that a condition limiting the benefit of the permission to a company is inappropriate because its shares can be transferred to other persons without affecting the legal personality of the company. And I think, yeah, we would ask you to reflect, sir, on the guidance there and in reaching your decision on such a condition and the need and requirement for such a condition.
Thank you. I'll go. Just sorry, Mr. Steele. I'll let you hang fire a little bit longer. Mr. Tilbury's raised his hand, so I'll let him. I'm assuming there's a response to what Mr. Collett said, so I'll let you pick everything up in the round, Mr. Steele. Mr. Tilbury.
Of course, just a word of clarification, sir. I wasn't in any way suggesting in mentioning the Ismaili community to try to place some sort of artificial restriction, as it were, on whom we considered members of that community. That's would be entirely inappropriate in terms of people who might have married into that community or whatever. I was trying to make the general point around that this building has been proposed for the use of a particular community which is not able, in the broad sense of what that community means, to fulfil its funeral rites in a way that it's comfortable with doing. And that's a fundamental purpose of this particular building in this particular place. I wasn't in any way trying to make any kind of point about religious practice.
No, I accept that, Mr. Tilbury. There wasn't a suggestion that you were. I think it was more about the evidence that I'd heard talking about and how that may be categorized for the purposes of a condition or otherwise. It wasn't a suggestion that you were implying anything of that nature. So just to put you at rest on that particular point. Mr. Steele?
Actually, so I'm going to jump in on the user point first before handing over to Mr.
Bonnier.
So what I'd say, it's not necessary. Clearly, all the evidence is this is a scheme specifically for and bespoke for the Ismaili community, and well, that's obvious from the fact that the appellant is the Ismaili Trust. But just because it's designed for the Ismaili community doesn't mean it needs to be subject, or a condition is necessary or reasonable. It's obvious that formulating a condition is problematic from the discussion that you've just had, but fundamentally, the scheme is so bespoke for the Ismaili community, you don't need a restriction. And there are various examples one could point to for that. Back in the days where people used to build superstores, they don't really seem to do so now. You'd have an Asda type superstore, you'd have a Tesco type, and if you had a design, or similarly, for example, I think the most recent major stadium to get planning permission is Everton's. We use that because I suspect it's not controversial. Actually, I don't think there's anybody from that part of the country on this call.
Apart from me, Mr. Banner.
Actually, you're not that far off, are you? You're not that far off. But let's use Everton for an example. It's hard. Everton football stadium. If Everton need a new stadium, and they've got one obviously currently being built, there doesn't need to be a planning condition saying it should only be used by Everton, because it's hardly likely that Nottingham Forest are going to move there. So I hope that kind of gets the point across. You don't need a restriction where the actual design and development is so sufficiently bespoke for the user that deals with the point about, well, will the need actually be met there?
Thank you, Mr. Banner.
I'm a West Brom fan, by the way, so I think
sorry.
I'm a West Brom fan, so neutral in relation to Everton.
I'm also neutral in relation to Everton.
That's very good to hear.
I'll just leave that there.
Good.
Mr. Steele.
Thank you, sir. Yeah, it was just to pick up on the discussion about the terms of the condition relating to the use of the pavilion building. So yeah, I appreciate what's just been said and that in respect of the visiting graves point on that. I think it's also important also reflecting on your comments regarding enforceability, particularly regarding arrivals and departures. I think it's appropriate for the hours of the use of the building to be fixed as stated rather than expanding the condition in terms of when people can arrive and depart. I'd also say that the hours that are stated provide an hour buffer between the peak hours, AM and PM. And so if there were some early arrivals, etc., or earlier arrivals, that hour buffer would be there. And I think that then gives necessary comfort to the condition that it would do what its purpose is for, and that the condition can be enforced by the use of the building rather than by arrivals, which I think would be problematic. Thank you, sir.
Thank you, Mr. Steele. I've got a hand up from Councillor Powell, so I may return to you, Mr. Steele, as a response to Councillor Powell. Councillor Powell.
Thank you, sir. Just to be clear, the evidence that's been presented and that we've discussed is very clear around the fact that the transport assessments that were done were between 10 and 2. And from the evidence, which you will of course reflect on, there is still concern that the afternoon peak is related to school traffic, which actually starts at 3 o'clock. So I would just ask to reflect on that in terms of what Mr. Steele has just said. And I would also ask you to reflect on the highway response. So that's document 4.14, which does raise concerns about the northern traffic as well as the southern traffic, which is obviously also something that has been raised. And the capacity of that junction obviously has not been assessed. So I would just ask you to reflect on the statement regarding operating hours, sir.
Thank you, noted. And I obviously don't want to stray too much. There are points that you've raised previously on day 4, so I am reflecting on those particular points. Mr. Steele, any final comments to add?
No, just other than you've got the evidence, sir, to take a full review in terms of highway impact.
Thank you. There's no hands raised, so in that case we'll move on to condition 19. So we're getting towards the end. I think just in terms of time, we are getting close to what will be the lunch break. I can confirm I have received from my case officer the closings from Mr. Banner, and we'll deal with them just once we've completed the condition session. I don't want people to sit too much in discomfort, so my suggestion is that we potentially finish off the list of the conditions, which hopefully we should do around about 1 o'clock. We then take an hour's lunch and we resume and finish off the condition session, and then we maybe take a very short adjournment to prepare for closings and to allow anyone who's not interested in participating, which should be pretty much everyone, where they can either retire into the background to observe. Does that sound sensible? Because the alternative would seem to be having a short break, but we're delaying lunch to quite considerably, and people obviously may need a sustenance just to keep themselves going through the day. And it does seem like we have enough flexibility in the remaining programme for the remainder of the day that the closings can occur today, and the inquiry can be closed at that particular point. Any comments, Mr. Banner?
That's absolutely fine by me. I would be happier with a shorter break too, if you wanted one, in the sense that I'm ready to go, but equally if you wanted a full hour, that's absolutely fine by me. So totally flexible as far as I'm concerned.
Well, I'll take the reflection, but obviously we'd probably look to reconvene at 2 p.m. and then finish off on IQ 13 before we move to closings. Okay. Mr. Collett, you've got your hand up.
Yeah, thank you. So it wasn't about timings. I'm absolutely happy with, whichever route there. It was just, and I can't remember, and apologies if it was mentioned at the start of the session, you mentioned you received Mr. Banner's closing. Have you also received Mr. Green's?
Yes, I mentioned
You
it in
have.
housekeeping. It's
Okay, apologies,
IQ
I couldn't
14,
remember.
IQ 15,
Yeah.
IQ 16.
Thank
Yes,
you. Yeah.
I'll deal with Mr. Banner's closing, which is likely to be IQ 70, but I haven't. All I've noted is I've received the email. I've not noted the document, so I will review those during the break before we deal with them in housekeeping. Councillor Powell.
Thank you, sir. Very much welcome the break. I certainly need a comfort break, so I appreciate your consideration of this fact.
Yeah.
I would very much appreciate it if IQ 13 could be shared with interested parties. It will make the discussion after lunch so much easier if we've seen the document, if that would be okay.
Happy for that to be done. As long as if the council or the appellant wish to do that, and it's just confirmed when we return from the lunch break.
Thank you, sir.
Okay, and like I said, I don't wish for you to sit in discomfort. But around about 5 minutes, would that be okay? Okay, fine, thank you. So we'll move up. We'll move swiftly on in that case to condition number 19. So we've got 3 conditions remaining. The only query that I had was just about construction traffic routing. There are some proposed wording changes in the conditions. It's a construction environmental management plan. There are proposed wording changes into parts 9, 12, 13 and 14 and the implementation clause, but those are largely to reflect, they're already in IQ 11 that people can see, and they're to reflect precision for similar matters to previously raised, and to make the implementation clause more precise and enforceable. The one point that remains of dispute, I'm happy to take anything away other than if people's got comments, is just in relation to part 6 and the construction traffic routes which we raised. Now, it is a matter that's often raised by inspectors because it is a standard condition that's suggested where about trying to control construction traffic routes and the difficulty of doing so because it lies outside of the red edge application boundary and the control, how that would be particularly enforceable. Obviously, we've already heard comments on land ownership in terms of site access and issues of that, so we don't necessarily need to rerun any comments on that particular point. But what I was looking for was a little bit more from the council, because the council have suggested that they do consider it appropriate construction routing on the highway network. Looking at it, it doesn't seem to me that the condition actually imposes a level of control on construction routes. It's more indicative of how those construction routes will be achieved. In the event that I consider that particular point raised by the council on it, is that the intention, and it's more a negotiating point rather than an intent of imposing specific restrictions on construction routes? So, for example, the council can advise the appellant on issues informed by the highway authority in terms of restrictions such as, like, for example, low bridges and things like that for construction traffic.
Absolutely, sir. Yeah, there is no, I think, intention at the moment or any routes to the site that are in mind. As you said, it is a fairly standard part of these types of conditions, and it's more about in this case the appellant basically advising how large construction vehicles would get to the site, particularly trying to prioritise it. And I'm talking typically in sites I've been involved with previously about prioritising the primary highway network in order to keep vehicles on that on those types of routes as far as possible until you get to more local roads towards the site, rather than perhaps allowing, for want of a better word, a free-for-all on any type of road that might have a greater impact from large construction vehicles. But obviously, sir, happy for you to reflect on your thoughts on the inclusion of that part of the condition. But I would, in your review and reflection, just direct you to CD 11.1, which is the appeal decision for the Hawthorns, where the inspector, as part of condition 7, did include vehicle routing as part of a very similar type of condition.
Noted, Mr. Collett. Mr. Steele?
Thank you, sir. I think your comment on that condition has also made me reflect on whether that specific criteria is proportionate to the scale of construction that would occur from this project. particularly compared to that of the Hawthorns development, which is obviously a major housing scheme. So I'll just leave that with you, sir. I've got no further comments.
Thank you, Mr. Steele. Just on that point, obviously it was a position that you agreed in terms of that. It was more a query from me. So my assumption is you would be happy to return to it if I considered it necessary. I've reviewed the comments.
Yeah, I agree. We did agree to it, but just in reflection and in your assessment, essentially.
Yes, Councillor Powell.
Yes, so as referenced in the representation I made to you, the Farnham Infrastructure Programme is starting this week and will close the major A road that runs north and south through Farnham, the A287, for months on end, which will, the diversion route will go past the developments, this particular appeal site, for a period of time going north and for a period of time going south. So I do think that given the evidence we have heard, that if you are to choose to allow this appeal, that this would happen quite quickly, the ability to at least influence and discuss the routing would be really very helpful in terms of just keeping or giving Farnham any chance of keeping moving, given everything else that's going on, because there are a lot of other developments as well. It's a cumulative effect that's the concern. So, but if you
thank you, Councillor Powell. Any final comments, Mr. Steele? In that case, I know I said we'd try and get to the end of the conditions, but we have reached 1 o'clock, and I am conscious that we've been going for over 2 hours now. So it would be sensible to me now to take the lunch break, adjourn until 2 p.m. Then we'll pick up the final discussions on the conditions remaining on IQ 13. And then take a very short break to allow people to arrange themselves ready for the closings. I assume that's all agreed.
Yes, thank you.
Yes, sir.
Thank you very much. Well, in that case, it's 1 o'clock. The inquiry is adjourned until 2 o'clock. If everyone can just mute the microphones and turn the cameras off until we resume. Thank you.